Welcome to today's discussion on comparative religious liberty. I'm Jim Sonne. I direct the law school's new Religious Liberty Clinic. And although our clinic focuses on teaching professional skills in cases involving domestic religious liberty law, the themes we explore are universal and ones that have been with us from the founding and have been faced by those around the globe for time immemorial. Namely, how do we honor the natural right to belief and its manifestation, as Madison would put it, in an ever-diverse and pluralistic society. The cultural and historical circumstances in the United States, France, and Turkey may differ, but the question and the answers posed in those various contexts and in those important countries are ones in which we all should be invested and interested. I'm honored to share the stage today with four leading figures in the field of law and religion, and look forward to a lively and wide-ranging discussion. Before we begin, I'd like to give special thanks to the Stanford Constitutional Law Center and to Nathan Chapman for putting this event together. Today's event is but the latest in a continuing series of great programs that the center runs. It's now my privilege to introduce today's panelists and describe the format for discussion. Our first panelist is to my immediate left, Denis Lacorne. He's in many ways a 21st century Tocqueville, having written powerfully as a Frenchman about religion in American public life. Most recently in Religion in America, a Political History, a book I recommend highly. Denis is Senior Fellow at the Center for International Studies and Research at SciencesPo. I wouldn't be a true American if I pronounced that correctly.
Well,
the premier political science school in France. And professor at SciencesPo's Paris School of International Affairs. Professor Lacorne is also a scholar in residence at the Stanford Humanities Center. Our second panelist to my far left is Kabir Tambar, an assistant professor in Stanford's Anthropology department. Professor Tambar's work focuses on the Middle East and the Muslim world. He's written extensively on secularism in public life and the intersection of anthropology of religion and political anthropology. Professor Tambar's latest book centers on the politics of pluralism in contemporary Turkey, a secular national state, but one that is also almost exclusively Muslim, albeit in a particular way, much to the chagrin of religious minorities such as the Alevi, which Professor Tambar is a particular expert in. And we'll hear more about that in the discussion. Our third speaker is Jack Rakove, second from my far left. William Robertson, co-professor of history and American studies and professor of political science and law here at Stanford. Professor Rakove is a Pulitzer Prize-winning historian and the author of many prominent books and articles. He's one of the world's leading experts on James Madison, principal drafter of the First Amendment. And on a personal note, I had the pleasure last term of visiting Professor Rakove's fascinating course entitled From Heretics to Headscarves, which involved many of the issues we'll discuss today. Last but not least, our final speaker is the law school's own Michael McConnell, Richard and Frances Mallory Professor and Director of the Constitutional Law Center, the center that's sponsoring this program, as well as a Senior Fellow at the Hoover Institution. Professor McConnell is a leading authority on freedom of speech and religion, the relation of individual rights to government structure, originalism, and various other aspects of constitutional history and law. He's written numerous groundbreaking articles and books on these topics. Professor McConnell is a true Renaissance lawyer, having served as a law professor for many years, a federal appellate judge for many other years, and a practicing lawyer, having argued, I think it's 14 cases now before the United States Supreme Court. Given the nature of his recent work, Professor Lacorne, we've asked Professor Lacorne to begin our discussion by speaking about what he perceives to be the key distinctions between religious establishment or non-establishment in the United States and France. Then it's our hope that Professor Kabir will then discuss Turkey, and then Professors Rakove and McConnell will jump in with comments, insights, and questions, and then we will open the discussion to the table and to you for questions. Professor Lacorne?
Thank you very much. I'm delighted to be here at the law school, and I'd like to thank Professor McConnell and Professor Sonne, and as well as the Humanities Center at Stanford, who made it possible for me to spend 3 months here in the winter. So I'd like to start with just reminding you that in France we don't have a First Amendment to our Constitution, nor do we have an establishment clause and a free exercise clause, but you can find, if you look carefully at the constitutional text and laws, equivalent, a legal and constitutional equivalence. The starting point is the French Declaration of Rights of Man and the Citizen, 1789, which states that, quote, no one shall be disturbed on account of his opinions, comma, even religious opinion, provided the manifestation does not disturb the public order. So even public religious opinions. And then you have Article 1 of the current Constitution that states that France shall respect all beliefs. And you have maybe the most important law, which is not part of the Constitution. It may become, that was one of Hollande's dream, but hasn't taken place so far. The 1905 law, the so-called law of separation of church and state. And the first article of that law guarantees, quote, freedom of conscience and, quote, the free exercise of all religious beliefs, unquote. And then you also have the second article of that law that says, quote, the Republic neither recognizes nor provides funding for association of worship, which is very much the equivalent of the Establishment Clause. Now, in the French legal system, it is usually the administrative judge and the highest administrative court, which is the Conseil d'État, the Council of State, that gives meaning to that law of 1985, particularly when you have a conflict between a state agency, a person, and a private citizen, and sometimes expands its meaning. But other courts have been involved, one of which is the Cour de Cassation, which is the highest civil and criminal court in the French system, and the Conseil Constitutionnel, which is not quite the Supreme Court. Its role is more restricted. Its judges are usually not trained in law. That includes automatically all former French presidents. Sarkozy is a member of the French Constitutional Council, so they're less reliable, and their decisions so far are not as important, I would say. And yet, freedom of conscience, a fundamental right in the French political tradition, can clash, and does clash quite often, with another key principle, which is the principle of laïcité, of secularism, particularly as it applies to civil servants, public agents, and public agencies or organizations. And in France, when I say public agencies, that's a vast domain. We're talking of 56% of the budget, and that has to do with the schools, hospitals, so on and so forth. And then you have that, I mentioned possible clash, you have that other key principle which is listed in Article 1 of the French Constitution, and France is a secular republic. France est une république laïque. So let me develop the point. In the French juridical tradition, it is recognized that a civil servant or public official, an agent public, has the duty to observe the principle of neutrality. He or she cannot express an opinion, whether religious or political, which would favor a particular group or give the impression that she favors particular beliefs. Legally, of course, anyone is free to believe what he or she wants, and all religions are put on an equal footing, but a public official cannot publicly express his religious beliefs or lack of beliefs, nor can he or she wear visible religious symbols. And that's true of teachers, for instance, in primary or secondary schools. But outside the public service, the civil servant can do as he pleases. In a famous case of the Conseil d'État d'Arrêt Jamais, 1950, the Conseil d'État reappointed a public school teacher who had been fired because she had, during the school week, but during her free time, had attended the meeting of a religious group. That was outside of a regular work schedule, so it was considered perfectly proper for her to do that, and she could not be fired. And its duty to be neutral, and someone would call it the devoir de réserve, applies to all public officials, including those who are not teachers, but in fact operate in a public school. There's another decision to that effect. And then, and maybe that's the most interesting for you because it's more complicated, you have what I call a gray area in the law, and that concerns private organizations that may perform a public service or public task or public function, une mission de service public. Can a private school or summer camp or youth hostel be considered public in the sense that they serve a wide diversity of people's clients? Do they perform a public service, une mission d'activité publique? And should they be treated or not like a public organization? And the response today of the French courts is no. No religious activity, no religious symbols, no religious dress or attire, such as an Islamic veil, can be prohibited in the private sector, unless the symbol in question creates a major obstacle for the task that's being accomplished. So private employers cannot arbitrarily limit the religious rights of their employees, even if they pretend to be guided by secular values or secular concerns. In the private sector, the principle of secularism should not be invoked to hide a discriminating intent. For instance, the owner of a supermarket who pretends to support secular values cannot force a woman at the cash register to remove her veil simply because he doesn't like the veil or disagree with her religion or the way she dresses herself. So the question is, how far can the, quote, public sphere be extended? And we have a very interesting response that just came up March 19th, very recently, from the Cour de Cassation, which is, I will call it the Baby Lou case. Baby, like baby, and Lou, L-O-U-P, which is about a kindergarten. Now, the case concerns the firing of a teacher who, in violation of the school's dress code, wore an Islamic veil in a kindergarten called Baby Lou in the charming city of Chanteloup-les-Vignes. And her firing had been validated by two lower courts, it was finally invalidated by the Cour de Cassation. Now, the reasoning is the following. That kindergarten, private, even though it gets some subsidies from the French government, it cannot be considered as performing a public service simply because it accepts a variety of students from diverse religions. The prohibition of the veil only applies to public school teachers, period, or public school officials, period. And the Baby Lou case is fascinating because it raises a key question in French labor law, namely the question of discrimination. To fire a private teacher who's not an agent of the state, not an employee of the government, simply because she wears a veil, would amount to a form of religious discrimination that's not permitted by French labor law. A restriction to religious freedom is only possible if it is in response to, quote, an essential and determining professional requirement. I'm quoting the court here. A formulation which I would say can be compared to the US standard of heightened scrutiny. And this standard, by the way, an essential and determining professional requirement, is directly borrowed from European labor law. It is a European norm that has been incorporated into French law, a point well made by a very good French legal scholar, Ms. Gwenelle Calves. There is a similarity between what you call, I think in the United States, a ministerial exception, and what we call in France an organization or an association based on affinities, entreprise de tendance or entreprise d'affinité. Now, that affinity can be religious, political, related to a trade union. If, say, the kindergarten had been recognized as an organization based on religious affinities, it would have been quite possible to oblige the teacher to respect the organizing rules of the kindergarten and to fire the teacher for violating the rule. I mean, think, for instance, imagine a Lubavitch kindergarten. In this context, you probably could fire a teacher who takes a great pleasure in eating a ham sandwich in front of his students. In that case, it's possible indeed to discriminate for religious reasons against an employee that does not respect the internal rules of the organization. And maybe it seems to me, seen from the outside perhaps, that the Hosanna Tabor case is all about that in many ways. And I'd like to conclude with a possible analogy with the famous Piotti case in the United States. Now, in Employment Division versus Smith, the Supreme Court validated a state law that, as you know, prohibited the use of drugs, even used by a minority group of Native Americans. That decision was openly criticized by numerous religious organizations in the United States and led to a formidable lobbying of the Congress. It provoked, I cite here, Professor Eisgruber in his book on religious freedom, it provoked, quote, a political firestorm that has run for 15 years. And that lobbying ended up, as you know, with a law that made it legal to defend the unorthodox behavior or practice of minority religions, the RFRA, Religious Freedom Restoration Act. Now, in France, in many ways, we have the same result, but in the opposite direction. The Cour de Cassation's Baby Lou decision is right now attacked by a lot of people in the media, in the government, by what I would call a very aggressive secular lobby that is already proposing that the French Parliament pass a law permitting private schools, not public schools, private schools, and perhaps private businesses to ban the religious symbols used by their employees. In France, it seems that we fight the courts to expand the realm of laïcité, whereas in the United States, you seem to be fighting the courts to expand freedom of religion and limit the scope of the Establishment Clause. But I understand that the US case law is also evolving as suggested by the Hosanna Tabor decision. So let me finish with the following question. Why are secular groups, secular lobbies in France much more active than they are in the United States? A possible answer, I think, is that we are a much more secular society and for a long period of time, but I don't believe this is the proper or the final answer. This is not the best answer in any case. A key reason, I think, is that the fight for secular values is in fact often in France, and more so today, a cover for discriminating against an ethnic minority which is disliked by the majority of the French. It can, in fact, be a cover for plain old racism. And consider this rather disturbing, if not alarming, poll that was just taken by Ipsos in January of this year. The finding in the following: 74% of the French and 81% of conservative Frenchmen think that Islam is not compatible with the values of the French society. 54% of the French think that Muslims are all fundamentalists. So this is why the fight for secular values is now so strongly supported, not just by the left, it's a traditional part of the left, but also by the extreme right, by Marie Le Pen's National Front, and very xenophobic groups such as Riposte Laïque or Bloc Identitaire. What we have, I think the problem we have, is that we are, in France, a multicultural society which does not want to admit that it is multicultural. Hence the French passion for, it's an old Jacobin tradition too, by the way, but the French passion for uniform rules, for universal and generally applicable laws that are designed to limit the rights of religious minorities, the latest being the law that was passed in 2010 that prohibits the wearing of the niqab or the burqa in the public space considered in its entirety, the streets. But there are definite limits to this unfortunate trend, one of which is the incorporation of European liberal law into French law, particularly according to Article 19 of the Treaty on the Functioning of the European Union and a European directive, which both posit the principle of non-discrimination and apply it to religious matters. That's a new thing. As for the prohibition of the niqab in the public space, it's likely to be invalidated, I would think, by the European Court of Human Rights because it violates too many existing rights and because even though it pretends to be neutral, it discriminates, in fact, against a single religious group, conservative Muslim women. Thank you.
Thank you, Professor. Professor Tambar?
Thanks, Jim. And let me start by thanking Nathan Chapman for inviting me here and to the Stanford Law School in general. I'm honored to share the stage with such a distinguished audience. Discussions of religious liberty in Turkey are often pitched as all or nothing. Either Turkey protects religious liberty or it fails in some measure to do so. I want to suggest a different way of thinking about the politics of religious liberty. Turkey has a lengthy history of secularization, extending back to the 19th century. From the 1830s on, the then Ottoman state committed itself in formal terms to protecting the rights of all individuals, regardless of their religious background. In Turkey today, the constitution officially protects, again in formal terms, the freedom of religious expression. But this constitutional protection has never, and certainly today does not, close political debate about religion. It opens it up in certain ways. So what exactly does the law protect? Whose understanding of religion? Religious liberty is a contentious concept, but not in the sense that anybody really disputes it in principle. It's contentious in the sense of how people interpret its practical significance. So let me take one example to start, perhaps the most well-known example from Turkey, the banning of Islamic headscarves from university campuses. There's no formal law akin to the French that bans the wearing of Islamic headscarves in Turkish schools. But since the late 1980s, and especially since the late 1990s, the Constitutional Court in Turkey has claimed that wearing a headscarf is not protected by law. The claim is not, in fact, a formal prohibition on the headscarf. It's not, formally speaking, a legal ban, but it's effectively a kind of abandonment by the law. University administrators in the last couple of decades have had the de facto authority to prevent the headscarf from being worn on campuses. At the same time, leaders of the armed forces, which are often seen as adamantly secularist in Turkey, have made public pronouncements calling for an outright formal ban. There's something, this is more of a side note, but there's something here that I think is worth lingering over, the difference between outlawing a practice explicitly and refusing to protect it, between banning and abandoning, as it were. We might ask, is religious liberty as a legal principle under threat in the case of abandonment, or only when an actual legal ban is put in place? What makes it hard to decide is that the law has not officially prevented the wearing of headscarves, but it has refused to prevent the practice. In 2010, a law was passed that was meant to offer some protection. The law stated that no one will be prevented from attending university for any reasons unless otherwise stipulated by the law. The law did not specifically address the issue of headscarves. It didn't explicitly protect the wearing of headscarves in universities, but it was meant to impede the efforts of those who are trying to keep women with headscarves off of campus. The headscarf debate in Turkey is often framed rather simplistically as a fight between a secularist elite that has ruled the country for almost a century and an increasingly politicized pious middle class committed to public displays of their religious devotion. The framing leads us to a seeming paradox. On the one hand, religious liberty is a key principle of secularism. On the other hand, it's the so-called Islamists in Turkey who are promoting this principle against the secularists. But there's a problem with this framing. First of all, Turkey doesn't simply have a clash between devout Muslims and ardent secularists. For the most part, the mainstream debate about the headscarf seems to be articulated as a fight between two different models of secularism. A secularism that is actively interventionist, that allows the state to control religion, and a secularism that is looser, less about controlling, and more about protecting religion from undue institutional constraint. And interestingly, in Turkey, these two models of secularism are sometimes said to correspond to French and American models, respectively. A French model in which the state is ardently secularist, protecting itself from the interference of religious authority, and an American model in which religion is meant to be protected from state interference. In Turkey, ardent secularists often feel that religious expression must be strongly controlled by the state, lest Islam come to be co-opted and perverted by extremists. Others, those who are sometimes called Islamists, do not tend to counter these arguments by advocating for the adoption of Islamic law to replace the secular system. Indeed, there are no mainstream groups in Turkey that advocate the wholesale replacement of secular law with Islamic law. Instead, these Islamist groups argue that a more authentically secular system must be put in place, a system that does not place excessive constraints on religious expression. The debate, then, is not between secularism and Islam, but between different models of, different interpretations of what secularism consists in. So let me turn then briefly to a second example in Turkey concerning a Muslim minority called the Alevi. Alevis are, loosely speaking, connected to Shi'i forms of Islam. Turkey's Muslim majority is Sunni, and Alevis constitute approximately 15% of Turkey's population. So they're a numerical minority. But many Alevis themselves dislike the word minority, since it carries connotations of being foreign to the nation, belonging somewhere else, and being granted special provisions in this locale. Many Alevis themselves are often at pains to insist that they are foundational elements of the Turkish nation, that they were early supporters of Atatürk and his secularizing project. In other words, many Alevis themselves stake a claim to the Turkish past and the constitutional narratives that entails. But this claim is part of a broader set of political contentions, some of which involve the idea of religious liberty. Many Alevi groups in Turkey today argue that the Turkish state systematically discriminates against them, and their principal example of this is the Directorate of Religious Affairs. The Directorate of Religious Affairs is a state institution that's in charge of organizing mosques, training preachers, vetting sermons, and the like. Interestingly, the Directorate was established in the early years of the Turkish Republic as part of a large secularizing overhaul of the legal system. The Directorate was the major institution charged with regulating Islamic expression, controlling its permissible form. So in many ways, historically speaking, the Directorate of Religious Affairs was an institutionalized expression of secularism. However, Alevi organizations today claim that the Directorate represents only those forms of Islam, Sunni forms of Islam, that are accepted by the majority population. Other forms of Islam, such as those adhered to by Alevis, are neglected or misrepresented by the Directorate. So certain Alevi organizations argue that the Directorate of Religious Affairs must be abolished, and only by doing so will Turkey actually become truly secular, truly capable of protecting religious liberty for all. So once again, what we have here is a debate over how to interpret religious liberty, how to interpret secularism, what institutions are necessary for its enactment or impede it. So I'm going to conclude very quickly here. I didn't want to take up too much space with my own voice. Let me conclude quickly with a few last remarks about why I think Turkey is fascinating for thinking about religious liberty in a comparative global context. And I think there's at least two reasons for thinking that. First, as I've been discussing here, many people in Turkey who are involved in these debates about headscarves and state institutional structures have started thinking about Turkish legal order in terms of other salient global models, especially the so-called American and French models of secularism. So efforts to debate constitutional principles in Turkey are very explicitly being set in a context that's irreducibly global in scope, that operates with a set of alternative possibilities. And this has arguably been the case from the early 20th century on, when Turkey started adopting European legal codes. But the point is that today, it's not merely a matter of adopting legal codes wholesale. It's about creating new possibilities for interpreting the existing legal structure, for defining its past and its present. It might be worth thinking about this comparatively. To what extent are debates about religious liberty in the US and in France influenced by globally circulating models? So, for instance, and these are some open questions for which I don't have an answer, do Muslims in France ever appeal to an American model of secularism in order to challenge legislation against headscarves? Or do indigenous groups in the US, pursuant of religious liberty, ever look to models of indigenous rights activism in places like India or South Africa in order to find other models of political activism that might be incorporable into this context? The second point about the global character of religious liberty. Increasingly, the European Court of Human Rights, of which Turkey is a participating member, hears and adjudicates cases that involve how religious liberty is legally applied in Turkey. In one landmark case, the ECHR, or the European Court, decided on a case in which a political party that had been banned by Turkey's constitutional court because of its purportedly Islamist ambitions had been banned by Turkey's constitutional court because of its purportedly Islamist ambitions, its perceived threat to secularism. In that case, the court decided that the ban should stand, despite the fact that the political party in question was democratically elected. Its forced closure was deemed necessary as a way of protecting secularism. And there have also been court cases brought to the European Court having to do with headscarves, having to do with the prevention of women trying to attend university with headscarves that the European Court has had to settle as well. So the task of interpreting constitutional principles, of deciding when they have been violated and so on, is already being recast in a global manner, being submitted to the scrutiny and judgment of a court of international law. And it might be interesting to think about whether anything comparable is occurring in North America or Western Europe, and I'm interested to hear more about the case you just mentioned about the European Court taking up some of these issues like niqab ban and so forth. Thank you very much.
Thank you, Professor Tambar.
Well, it's a little hard to know where to jump in here, but I was just sitting here, I was just thinking some years ago, I think it was 1986. It was actually right before the synagogue massacre in Istanbul. The week before, I attended a bicentennial event in Spain with, I think, a former colleague of Mike McConnell's, at least a federal district judge from Denver named John Kane, I think. And
He's still.
yeah, still there. I'm going to the 10th Circuit, so I hope to see him. And we had to do a mesa redondo, a round table or whatever, on issues of religious liberty, separation of church and state for a group of primarily Spanish graduate students. And we kind of went through some of the standard discussions of the origins of the American concept and basic outlines of the law. And then when it was over, the first question that came from a Spanish student was, how does this relate to the Catholic Church in Spain? And we felt that this is one of those strange moments when, having tried to explain that, there are kind of basic barriers between how the United States would regulate any one church, the intuitive response was still to ask, but there must be some special relationship between the state and the church that's worth spelling out. And that's an earlier reminder to me of the difficulty if you operate within the strongly Madisonian, Jeffersonian tradition that I do individually, of the difficulty of trying to make the leap from the American situation to that we find in most other nations. Now, I think Denis has argued, and this may actually pick up on Kabir's point, that what might seem to be at first glance a kind of radical disjunction between the American position and the situation we observe in other countries turns out to be a much more complicated situation. And I know Denis has explained this to my class. There's actually some really interesting connections between what French observers of American practice and American arguments in the late 19th century thought they were observing and the legal development of the doctrine of laïcité in the early 20th century in French legislation. And Kabir has just said, which I think is a great question to ask, what impact, if any, does some understanding of an American model or kind of American notions of religious liberty and separation of church and state have for contemporary understandings of religious freedom around the world? I think that's kind of an interesting question that's kind of worth pursuing. It's of interest to me, obviously, as an Americanist with a kind of particular interest in the origins, particularly the 18th century origins of our conceptions, but it may well be a kind of fruitful question for us to pursue as well. Let me toss in a couple other thoughts here. One thing I realized when I taught this course, From Heretics to Headscarves, which is a great title, but I also think the course content is pretty good as well, is that when we live as we believe we do, and I think correctly, in a society that is religiously tolerant, we no longer really understand what toleration is. There's a kind of deep paradox in, I think, the history of religious toleration, which toleration in its proper original meaning, in the meaning that's being worked out both philosophically and pragmatically in the 16th, 17th, and 18th century. What toleration originally means is you have to accept something. You have to learn to coexist with something that you find deeply offensive, burdensome, painful, to have to accept. And Europe makes its way towards a tolerationist position because the costs of not pursuing toleration become too high in terms of bodies and civil strife and civil wars and the like. So as Europeans work out the question, Americans pick up and then move well beyond what the Europeans have done. The first phase of this process is you have to overcome things you find profoundly distasteful. It may be attitudes, I think in the European case, it may be attitudes towards transubstantiation, what you think about the host, what you think about communion, what you think about the other sacraments is just an issue that plunges deeply into European sensibilities, and you have to learn to accept positions you find one way or the other deeply offensive. But at some point, you work out what a model of toleration is, and the more successfully you pursue that, the more difficult it becomes to understand what toleration really is. That's to say, we, and I think when I say we here, I think I mean primarily Americans, we live in a regime where we accept religious difference pretty much as a matter of course. Now, I don't want to say this universally because we know that in the United States, as in France, in some communities, the presence of Islam is problematic, that the the fear that Sharia might be adopted by some city council somewhere, which to me, most of us seems, wholly fanciful and absolutely incredible. Nevertheless, does seem to be an active part of the political psyche, at least in some communities. So we don't want to exaggerate this. But on the other hand, I think Americans are correct to say that we live in a world, we live in a society where I think on the whole we have become religiously tolerant in remarkable ways. Religion's kind of a curiosity, and we accept a great diversity of viewpoints, and without agonizing about them too much. And as a result, we don't fully understand what toleration really means. For us, toleration has become kind of a moderate virtue. It's a fairly easy norm to practice. And so I think what makes thinking about the French case and the Turkish case, insofar as I understand them, interesting, and insofar as the conflict either between secularists and Islamists in Turkey, or the difficulty of living in a countercultural society and not recognizing it in France, might prove, is that it serves to remind us in some ways of a kind of a deeper conflict, that the existence of profound religious difference or profoundly different attitudes about secular values versus religious values in those societies, I think it's more difficult for Americans to grasp and to make sense of and to interpret, precisely because we become such tolerationists. We're not merely tolerationists ourselves. And so I think trying to think about, pick up on Kabir's point, perhaps inadvertently or otherwise, the way in which American practice has, on the one hand, affected, influence in some ways, helped to shape either legal practices elsewhere or at least intellectual understandings, seems to me to be an interesting problem. I mean, something worth thinking about. But I think for Americans, it creates a particular hurdle because the world of fundamental religious difference is one we're no longer very familiar with, except in some odd communities where it manifests itself in kind of esoteric ways. I also want to say, Denis, just one point that I wanted to mention is when I was curious about what you said, when secular lobbies are much more active in France than the United States in terms of litigating this. I'm not sure. I think there are many people who say the same thing about the American Civil Liberties Union and and other institutions. So I wonder about at a lesser point how much of a difference there really might be on this front. So, James, turn to Michael. Yeah.
Like Jack, I feel a little like jumping into a pool with all kinds of interesting things going on. But let me just say just a few things. First of all, France, U.S., Turkey. Great set of comparisons. Let me make a generalization, and I don't know if Kabir and Denis in particular will agree with this, or even Jack would agree with this, but it seems to me that the U.S. and France began in very different places philosophically about religious freedom. In fact, if the central idea in France is laïcité, and the central word we would use in the United States is religious freedom, those are in themselves, quite different ideas. And it seems to me we began in very different places, but have ended up, at least in the law, not that far apart. As I listened to Denis going through, a series of very specific examples of things that have gone on in the law in France, there might be mild differences here and there, but the ministerial exception seems to be somewhat similar. The treatment of the problem of exceptions from generally applicable laws, at least a similar. The Baby Lou, is it pronounced Lou case? Yeah. Interesting case. Probably come out the same way in the U.S. because Title VII of the Civil Rights Act of '64 protects employees of employers from religious discrimination. But I would think that if the school had a non-religious view or a secular view or an actual position to which they would say that the wearing of a religious symbol was inconsistent, that they would prevail on that and should prevail on that it's no more, just as a Catholic school would be able to insist that their teachers not flaunt anti-Catholicism, I would think a secular school understood as such. I don't mean just a non-religious school, but an actually secular school would be able to insist that its teachers behave the same way. So the differences in the particular cases seem very small. I want to come back to the differences at the beginning in just a moment, but to contrast this to France and Turkey, where it seems to me that the Kemalist secularist view in Turkey, coming out of at least 1920, if not earlier than that, strongly resembles the philosophy of laicite. And when you read at least Western descriptions of the two, you might think that Turkey is just a more intense, maybe more controversial example, both of them being countries where you have a revolution against an ancien regime that was associated with a particular religion, which is demographically overwhelmingly dominant. So both in France and in Turkey, the preceding regimes, heavily associated with a religion, and that religion, completely demographically dominant, and an establishment of secularism, of laicite, as a means of protecting that new regime against the sort of ideological pull of the religion, which is, and with the religion being not entirely comfortable with the ideology of the state. Now, the United States, and it seems to me that, so France and Turkey seem to have a similar, I'm going to call it a founding, that's not necessarily right at the beginning, and yet enormous divergence, so that today I would think that, if we went through specific cases, Turkey and France would now be looking hugely different, whereas France and the United States are looking much more similar. Now, back to the beginning, the interesting thing about the United States is that our revolution was not one in which the dominant religion of the nation, if we can view Protestantism as a religion, the dominant religion of the nation was not associated with the ancien regime. Quite the contrary. The most Calvinist, the most Protestant ministers in America were enthusiastic supporters of the revolution. King George III, when asked how they lost the revolution, attributed the loss to what he called the Black Regiment. That didn't mean the African American soldiers. That meant the Protestant ministers who wore black robes. They were the Black Regiment, and they were. And George III believed that that was what the American Revolution was about, and arguably with some exceptions, maybe Thomas Jefferson, maybe a few more, but it's very broadly believed in the early years of the Republic that the Protestant teaching, which means essentially that every person has an equal ability to read and understand the Bible for themselves and to carry it out, that essential idea of Protestantism is the same as the essential core of republicanism, which is that every person has an equal ability to be able to evaluate other important things and carry them out for themselves. And so instead of needing to have a sharp break from the Catholic past or the Islamic Ottoman past, the new American Republic was perfectly comfortable with the religious status quo, and so we didn't need anything like laicite or secularism. But at the same time, they were very worried about the corruptions of government, because our founders' experience of the Church of England was not a happy one. But it wasn't because the Church of England was foisting some kind of religious, unwelcome religious ideology on the Americans. It was that the Church of England was such a mess and it was manifestly being manipulated for political purposes, which was a corruption of the gospel. And so for them, the need for the country was not to change the religious character of the nation, but rather to cut the government out of it, so that the churches would be, and not just churches, but free individuals, because the hyper-Protestantism of the late 18th century was not particularly oriented around the organization of ecclesiastical structures, but for the people and their free associations to be able to practice their religion without the distortions of government. And I hasten to add that the distortions of government might come from regulatory control, but they might just as easily come from blandishing money with all the control that comes with it. And so you see that the Baptists, for example, were just as much opposed to financial support of religion as they were for having, uniformity acts or other statutes which told them what they had to do. For them, those two forms of government control were equally dangerous, and so it was a kind of independence from the government that was behind all of this. All of which makes me highly applaud Kabir's distinction between the two types of secularism. If you remember his description of this, which I think is, it may come out of a Turkish experience, but it maps onto the American very well, that one kind of secularism is an aggressive governmental intervention with the purpose of trying to control dangerous, that is dangerous to the regime, religious sensibilities, and make sure that they're not going to erupt into anti-regime or anti-social behavior. The other is one that says leave the religious life of the people alone, and that I think is the central core of the American view. Thank you.
Thank you, Michael. Denis, I had a quick question picking up on what Michael was just saying about if the differences truly are smaller, why the cultural divide? In your book, you talk about the perceptions that French people have of the American understanding of religious liberty, and vice versa, because I think certainly to the random reader or follower from America looking at the headscarf controversy, it's a little bit of a head scratcher in the sense of the perception that France is so advanced and liberal, and that why would it all of a sudden have this seemingly draconian crackdown on headscarves?
Yeah, two things here. It's true, in my book I'm very interested in the way religion evolves as defining the American identity, but also the way the French look at this religious and political scene from Voltaire on. At the time of the Enlightenment, most elites in Europe, particularly in France, are anti-religious. And they are looking for models of counter-religions. When Voltaire writes about the United States, he couldn't care less about the Puritans or Protestantism. That's not interesting for him. What's really interesting is the Quakerism, because he sees in the Quakers a kind of inverted Catholic Church, a religion without sacraments, without priests, without ritual in a Catholic sense of the term. So he sees it as a kind of a utopia of a non-religion that hopefully will come to Europe. And he builds this imaginary story of Philadelphia being the golden age and the golden place. And in France in the 18th century, we're looking for an example of the decay of religion. That's the Enlightenment. And what's interesting, when we look at the American Revolution, what we like, we do not write about the fact that indeed preachers in the United States supported the revolution. In France, when the revolution took place, it was against the Catholic Church, so that's a big difference. Of the Catholic Church, which was almost a unique church, because we expelled, after all, the Huguenots in 1685. We expelled 250,000, the largest successful religious minority that existed in France had been destroyed by Louis XIV. So we became a mono-religious state, and when the revolution takes place, it's a revolution against a single church, the Catholic Church. So when we look at what happens in the United States in the 18th century, there's tremendous fascination for the one spot where indeed there was an established church, the Church of England in Virginia, and there's fascination for Jefferson's Bill on Religious Freedom in Virginia, which calls for the disestablishment of the Anglican Church and the end of subsidies, of taxes and so on of the church. It is true to protect other minority religions like the Baptists, but that is so fascinating for the French that the minute that bill passes in the Virginia House, which is late, 1786, it takes 10 years for it, thanks to Madison lobbying, the minute it passes, within a month, the entire bill is translated into French, published in Demonier's Encyclopédie Méthodique in 1786, 3 years before the French Revolution. And so we start to discuss separation of church and state the way it exists in the United States in France 3 years before the Revolution. And I find that quite interesting and quite revealing. Now later, of course, the term wall of separation comes much later, and I suggest that it comes from James Berg, which was an important source of information for Jefferson. So there's that fascination. And then in France, secularism became quite radicalized because it fails, because the French Revolution fails. So the French Revolution tried to disestablish the Catholic Church, and it doesn't work that well. Half the priests refuse to become ministers of the or to become civil servants and to pledge allegiance to the Republic. So there's a rebellion within France. Then we have with Bonaparte a concordat, an agreement with the Vatican, and something else than secularism, and it will take nearly another century to really establish a secular system, which strangely enough starts in the schools. We first create a separation of school and church, and then church and state. And the key element in the key leader in that change is Brisson, who was Jules Ferry's right-hand man for the secularization of France under the Third Republic, and he wrote a wonderful little dictionary called Pedagogical Dictionary, and he has the first dictionary that has the article laïcité, which he defines in the following way. In 1911, laïcité essentially is the separation, the increasing differentiation of between the role of the clergy and the role of the state, which, quote, reach a complete clarity with the French Revolution. We have with complete clarity, quote, the idea of secular state, a state neutral with regard to all forms of worship, independent of all clergies, free from any theological views. And that view is strengthened by his visit to the United States at the time of the Philadelphia World Fair in 1876. He writes a 600-page report on schooling in the United States. It's the time of the Blaine Amendment. And what he loves is the fact that more and more states, the Blaine Amendment will not pass in the end, but more and more states are asking that there be no public subsidies for public schools. We find that wonderful, and it's an idea that should be applied, and which indeed will be applied to France, even though we've abandoned that idea since then, because today most confessional schools in France are financed by the French government, which is something which hasn't yet taken place in the United States. You have the voucher system, but it's very limited in France. 90% of the French confessional schools are financed by the French government. So that's a big difference. And to come to your second question, which is also a question that was raised by Jack Rakove on the difference between France and the United States, I think that everything becomes more complicated when you mix religious issues, concerns, and immigration. Now, France, very much like the United States, is an immigrant country. But if you look at the big waves, not as big as yours, but significant waves of immigrants that come to France in the 1900s, 1910s, 1920s, They're Polish immigrants, they're Italian immigrants, and later Spanish and Portuguese. They all share the same religion, which is a dominant religion in France, Catholicism. And by the way, the leaders of the secular movement in France are almost all of them Protestants or ex-Protestants. So the black robes also perhaps have a role in France, but different. And the big change with the current immigration, which in majority, or at least maybe over half of it is Muslim or come from Muslim countries, is that for the first time in French history, we have a religion which is quite different from the one that we know. And even though Catholicism is collapsing in France, only 8% of the French still attend church on Sunday, only 50% of the French identify themselves as Catholics, we basically have kept Catholic reflexes. And some have argued that our secularism is really a catho-secularism, which privileges in many different ways the Catholic Church and is more reluctant to help other churches, other religion than the Catholic Church. And I could argue, if we had the time, that indeed the Catholic Church does have substantial advantages over other religions. But so when you mix immigrations and concern about immigrations and religion, then it can become a dangerous mix, which is not unknown in the United States. I mean, that's what happened in the 19th century with when millions of Irishmen came to this country. The Catholicism was their religion. It was very poorly accepted by the nativists. And you had what I have a chapter in the book on the Bible Wars. It was very difficult to accept the Irish, partly because their religion was so different from the dominant religion at the time, which was the rise of evangelicalism in the United States. So that may be the difference today with the United States today. Because your immigrants today, despite what Huntington wrote, was very concerned about too many Latinos coming to the United States. Well, Latinos have a religion which is kind of mainstream today in the United States, or nearly mainstream, so it doesn't create the same problem. Now, last point. What's strange in the French system is that the courts, and particularly the Conseil d'Etat, has always been very much open and favorable to the headscarf. There are several decisions of the Conseil d'Etat and advice that are in favor of wearing the students should wear the headscarf in schools, no objection. And it's the parliament that passes restrictive laws each time. In 2004, a law that prohibits any kind of headscarves in the schools. By the way, a law which is approved by the European Court of Human Rights, and I could explain why. And then another law that prohibits the niqab and the burqa in the public space, against the advice of the Conseil d'Etat, which thought that that law was too oppressive and violates too many existing rights and probably will not pass muster at the European Court of Human Rights. So we have a court system that's quite liberal, quite protective of religious freedoms, and a parliament, because of this, quote, secular lobby, which is much more politics is at stake, of course. It's not by chance that we prohibited the headscarf in school in 2010. That was 2 years before a presidential election, at a time when the National Front, the French extreme right, was attacking immigrants, Muslim immigrants, and attacking Sarkozy and the French conservative for not being tough enough on immigrants. So that's a good example of the instrumentalization of religion by politicians. We're going to ban the headscarf and I will win vote from the National Front. Well, that's not the way it ended in the end in 2012. Sarkozy was not reelected. So that's the dangerous mix of immigration, politics, politicization, which explains, I think, the kind of behavior of the French Parliament, which is quite different from the much more moderate, much more enlightened and complex views of the French courts.
Thank you, Denis. I had one other quick question before we turn it over, and that was Michael talked about Kabir's emphasis on the two types of secularism, but I wanted to follow up too on the banning versus abandonment distinction, and maybe ask Jack or Michael to comment. Would that work? Does that work in terms of toleration or in terms of the way in which we understand religious liberty in the United States, this banning versus abandonment distinction?
I've never heard this distinction before, but let me take a crack at it. If we're talking about within governmental institutions, it seems to me that there, at least from an American legal point of view, there's no difference. That is, it doesn't really matter whether there is a single law that prohibits, say, a religious practice within governmental institutions, or whether it is simply forbidden as a matter of administrative discretion. As a matter of U.S. law, those two things are the same. On the other hand, if we're talking about non-governmental institutions, the civil society institutions, then there is this, I think there is something to the distinction in that I think it is, at least from my point of view, from the religious liberty that I would advocate, that the government may no more require every private institution to be friendly to religion than it may require private institutions to be unfriendly to religion. That basically private institutions ought to be able to chart their own course. Now, there is a complication when we're talking about employment and other matters of civil rights, where, and especially because religion and ethnicity are mixed up together. So, but insofar as private institutions are charting a philosophy for themselves, they don't all have to be religion friendly. And if that's abandonment, well, I would just call it a kind of pluralism in which secular institutions have just as much a right to be secular as religious institutions have to be religious.
I was going to say briefly, I think there are a lot of issues of religious expression in the United States where I feel the adage de minimis lex non curat, the law doesn't stoop to trifles, ought to be a guiding rule. I mean, in Palo Alto, we had a big dispute about a decade ago about the Eruv, and the question, which is the symbolic space that Jews create around a community that permits carrying on Shabbat, on the Sabbath. And Palo Alto's way screwed it up badly at the first pass, and then the second pass, found a way to make it acceptable. I mean, I think it illustrates my earlier point that much of what we fuss about publicly is actually fairly trivial. I mean, you can think about the Ten Commandments issue as a case in point. You're, displayed or not, whether you do or you don't, it doesn't seem much depends on it. Now, on the other hand, as Michael was just saying, I mean, there are major areas of behavior, and of course, the healthcare debate, I think, would illustrate this, just as well, where religious organizations or issues of employment, equally, where religious organizations engage in a wide range of activities, which bring them, much more under the purview of, what it is the secular state wants to accomplish, and where it claims to have religious exemptions seem to me to have much more profound and sweeping consequences. They're not merely symbolic, but they affect the actual distributions of different kinds of legal benefits. There, it seems to me, there's much more room for litigation, and it was kind of striking to me in Denis' remarks, and I think this would apply to the Turkish case as well, but the existence of external norms in terms of the conventions of international human rights, whether European or even global in nature, create a situation, I think not unlike the American one in terms of how the 14th Amendment works to a basis for litigation. So I wonder about I'm not sure about, banning versus abandonment, but I wonder about how one distinguishes between symbolic expressions about which it's easy to get worked up, but which aren't really deeply consequential, versus areas of public policy where serious differences do emerge and claims for religious exemptions have a greater impact.
Well, I think we have, 10 minutes, is that right, for questions? So are we going to be using the microphones? Okay, if we could use the microphones, is that okay? Fire away. Yes. Would you mind stepping to the microphone? Yes, thank you.
This is all for posterity.
Yes. So in that case,
feel like now I should say something more important.
This
is actually specifically a question for Professor Lacorne, but I think relevant to the panel as a whole. Because something that you said surprised me, that the Irish, when they first came because of their religion, were not commonly accepted, and similarly, discrimination against Muslims in France is being used as a cover for racism in some cases. And the Irish not only were Catholic, but not accepted as white, and it's probably not coincidental that as they became assimilated or integrated, they became white as well, right? So this just made me start thinking that perhaps it's a broader issue of religion being used not only as a cover for racial discrimination, but actually as an avoidance of politicization of a particular group identity or membership. And so I was wondering if there have been efforts, whether strategically or more formally speaking, within the law to just say, let's abolish the category of religion, because now that religion has become politicized to this degree and that the wall of separation has been, in effect, instituted, any invocation of religion for or against is in effect a political statement. And so we should just treat it like political speech and say wearing a headscarf or other religious displays is a political action. So can that be regulated? Yes, surely. The same way that wearing a swastika in Germany might be banned for particular political or historical reasons. But then those opponents will have to say in what this political gesture or speech consists, and they will not simply be able to simultaneously classify it as religion and yet ascribe it simply to some unexpressed identity, right? They will have to then make more explicit what they're opposing. So I'm not sure if that's that analogy makes the connection stronger. But
no, I think your point is right, that there's no reason why religious expressions like political expressions should not be regulated. I mean, there's no reason why not to do it. The problem is that when you try to do it, then it really becomes messy. That's the problem. For instance, take French public schools. In principle, there's no we could express religious ideas and political ideas in school. There's no objection to that. And the tradition in France is that as long as you use non-conspicuous religious symbols, a small cross or a small star of David, that's fine. But when it becomes too conspicuous and maybe is perceived rightly or wrongly as an act of proselytizing, then should you block it? And the reasoning of the French Conseil d'État is yes, if it is a provoking symbol, if it is an act of proselytizing, we don't want it, that should be banned. The problem is how you determine whether simply wearing a headscarf is proselytizing or not. It's kind of difficult, and you have sociological surveys that give you contradictory results. Some claim that the woman wear a headscarf does it to put pressure on her members of her peer group who don't, and they're going to feel guilty or feel un-Muslim, and so they will also. So that's a question of pressure, but it's very difficult to prove. It could be a pure individual choice and not a group choice. And it becomes messy because in the tradition of the French laïcité, and I suspect it's the same in the United States, the judge is not a theologian. That's not his business. He's neutral. It's not for him or her to say, this is a bad religion, a bad ritual, a bad practice. It's not, unless there is, of course, if the body if there is genital mutilation or something which challenges the human body, then yes, of course, you should ban it. But symbols, who is to say the symbol is proper and not proper? A theologian could answer that, but is this the position of a judge? And that's why when you have a law that goes a little too far, that the prohibition of the full facial veil in France, the burqa and the niqab, that law is very, very problematic because it discriminates against a single group. And there are so many exceptions to that prohibition that no one sees how it's going to work. Again, you could wear a ski mask. You could be a dental assistant with a protective mask. You could be at Carnival. You wear a mask. So you have one exception after another. It becomes quite difficult to manage. The police themselves don't want to have anything to do with that because it's not a challenge to the French public order, and you're certainly not going to arrest a wealthy woman from Qatar who's shopping on the Champs-Élysées, and she may buy expensive watches, so they're not going to be arrested even though they wear the niqab, so on and so forth. So and then a judge came up with a very interesting observation that, in fact, in the Conseil constitutionnel, if you prohibit the niqab, and if it is a religious symbol, you cannot prohibit it in any kind of place of worship. Even, say, a Catholic church. And then if it is a religious symbol that cannot be prohibited in a place of worship, it has to be permitted for the person to move from her home to the place of worship. So it should be accepted in the vicinity of the place of worship. So he's to decide what is the vicinity, what is not. It's a horrible mess, and that's why that law is not going to be to last very long, I think. So, but it's very difficult. Yeah, it's a good question. The question, yes, I think we should be able to regulate political and religious expressions, but how far do we go? And in the United States, there's a wonderful decision. I think it's a Tinker case about political expression in the classroom, where should you wear a black band because you're opposed to the Vietnam War? Is that too much, too visible a sign or not? And I think the decision of the Supreme Court was that, well, it's not a conspicuous sign, it's not really proselytizing, it's a silent sign, so we can accept that. Now, is the veil a much bigger thing than a black band on the arm? That's open to discussion. So there again, I think we could pursue the comparison between the two societies and the two juridical systems.
Well, this is a very interesting, difficult question, and a very puzzling response, I think, from Denis, too. But so if I understand the question, it is as religion becomes political, as if it were ever not political, should we cease to regard religion as anything different and therefore regulate it as heavily as we do political speech? Of course, I would have said we don't regulate political speech particularly, and especially not on the grounds that it's proselytizing, which is to say designed to persuade, persuasive speech, especially in matters of politics and religion, I would have said, are at the apex of constitutional protection. Maybe when you said, if we mean disruptive, that's what Tinker was about, not whether it's proselytizing or not. But I also think that breaking down these categories between religious and political doesn't get us, or it gets us to places we don't want to be. We have nothing like an establishment clause for politics, and there's a good reason for that, which is that government is, suffused with politics. What would it look like to say that our government is supposed to be neutral with respect to politics? I mean, can the president not make a speech? The whole idea of equating religious with political viewpoints in the government in a sort of an establishment of religion context just strikes me as not plausible. But also it leaves out, in terms of individual conscience, it leaves out a vast amount of what religious activity is, because although I do think it's true that religion has political implications, of course it does, but it isn't just politics. There's a great deal more going on in religion than just politics. So something like the peyote case, to which Denis refers, the reason that is so important to protect is not because the Native Americans are expressing something or proselytizing something or persuading or having a political view. It's because this ceremony is central to their understanding of who they are and how they relate to the normative universe. And there's nothing in politics that is quite like a sacrament, right? And if we just tried to reduce religion to politics or to political speech, we would just miss so much of what is going on and what people find important about their religious practice.
We have another question.
I'm curious if you, thank you, this is fascinating. I'm especially from a kind of distinguishing identity from religion in the law. I'm interested in perhaps where you see the internet and the information age affecting questions of comparative legal freedoms in the France, US, and Turkish examples. And I ask this in the context of being the founder and president of a startup university which would like to have law schools in many countries, if not all 204 countries per the Olympics. We're world university and school like Wikipedia with MIT OpenCourseWare. So where is what are the trajectories ahead that you see for these comparative legal freedoms vis-a-vis the internet?
Let me, two possible answers. But to come back to the question I was raised about Turkey earlier, I think what's very important is that laicite should not be conceived or understood as a block, a unified block, something that does not evolve. I mean, it has evolved tremendously in France to the point that there's a chair of laicite now at the École des Études in France, and persons in charge, Portier, in charge of his chair, claims that laicite has evolved from a harsh, assertive laicite to a kind of welcoming laicite that's open to a lot of religious forms today. So there's to the point that now we believe that it's time to teach about religious issues in a classroom, because it's important to have some religious background, which we've lost or which we don't have enough in France today. So things have evolved. And the key question on how do we or not regulate religion is the question of financing. I think we always come back to that. Jefferson was concerned about it, so was Madison. Should we finance an established church? And today the question is, should we finance a confessional schools or not? Should we finance the building of a church or the building of a mosque or not? Very important issue in the current French debate. And we cannot do it. We cannot finance a place of worship. But since that would be unfair for the Muslims who don't have those churches that have been repossessed by the French government that are freely accessible for Catholics, there's a new compromise, and the new compromise is, well, we cannot finance a place of worship, but we can finance a cultural assembly that's attached, or building that's attached to a church or attached to a mosque, which is an indirect way of financing what we cannot finance, namely a place of worship. And that's something that exists today in France. But to come back to your key question about the internet, I can only tell you what I observed in France. And the use of the internet is dangerous in the sense that all forms of extremisms are freely expressed there. If you want a good example of harsh laicite and xenophobic laicite in France, Google riposte laïque or Google bloc identitaire, and you'll find the most vociferous anti-Islamic speech you could imagine today with a secular color. And vice versa. If you, there are lots of sites that are Islamists and denounce state France as a dangerous anti-religious nation that should be destroyed. So the internet, you get the best and the worst. And that cannot be regulated, although there are hate laws or anti-hate laws in France. And in France, they're probably harsher than they are in the United States. So you cannot openly challenge the Holocaust, for instance, in France, or be openly racist. So there's more restriction than you have in this country. But and how does that work on the internet? I don't know. It's complicated issues, but it's true that the internet opens up wonderful possibilities, but also the worst, and the worst in terms of religion and fanaticism. And so how do you control that? And is that a proper question? Can we control the internet?
And all I would say is the other side of that coin is the internet's very hard for the government to regulate, and therefore is in a sense a blessing, because it makes it so much harder for the government to regulate.
Can you say something on the Turkish aspect of this? Is there...
I don't have any specific thing to add. I think it's the same sort of, frame about the fact that on the one hand it seems to enable forms of speech that might not be permissible, not because of legal regulation, but because of sort of public propriety or whatever in other forms of public media. But on the other hand, in sort of, especially in rigid regimes, it also permits, forms of expression that might otherwise not see the light of day. So in some ways it's hard to answer with any, with certainty, because it's such an open area right now.
How did Turkey and Google work out their disagreement from a couple years ago?
I don't have a specific sense of that. I mean, I know Turkey's had issues with YouTube in particular, where every once in a while it'll shut down YouTube because of what gets, expressed there, and and there it's oftentimes, statements that are seen to be, anti-state or anti, foundational figures of the state and so forth. But I think it's a very, I don't know, this is a trite thing to say, but it's a very dynamic area that I think is not, it hasn't been tamped down that heavily, even as it has been regulated at various points in recent years.
Well, thank you, everyone. Please join me in thanking our panelists.